She flew in from America straight after his wife's funeral. He changed his will. This is Key and Key 2010. Section 1. The story. This is a case about grief. George was an 89-year-old farmer. He and his wife Sybil had been married for 65 years. She ran everything. George had never even made himself a cup of coffee. He was struggling, but he was still driving short distances, going to the pub, playing poker dice. He was managing, but then Sybil died suddenly. George was devastated. His GP found him desperate, not sleeping, and saying, "I'm not going to be here in 2 weeks." His daughter Mary flew in from America, and she discovered George's will favoured his sons and instantly decided that it needed to change. Within 6 days of Sybil's death, Mary had persuaded George to change his will. The family solicitor took instructions that Monday evening, and the new will was signed by Wednesday, straight after Sybil's funeral, which George was too distressed to attend. The solicitor never arranged a medical assessment. Section 2. The law. This case riffed around the golden rule. When a solicitor prepares a will for an elderly or seriously ill person, they should arrange for a doctor to assess capacity and make a written record. It doesn't guarantee validity or prove invalidity, but it prevents exactly the kind of dispute that ensued here. The case also developed Banks and Goodfellow. That test was developed in an important way. The traditional test focuses on comprehension, and you understand what the will does. But Mr. Justice Briggs recognised that severe grief can destroy something different, the mental energy to actually make decisions. A bereaved person may understand what's put in front of them, yet simply agree with whatever's suggested, not because they decided it's right, but because they can't form a view of their own. Section 3. The outcome. The court found George lacked testamentary capacity. The 2006 will was struck down. A psychiatrist who examined George 5 months later found him disorientated, paranoid, and unable to manage his affairs. He said he couldn't conceive that George had declined so rapidly from a state of capacity. The bereavement was no less serious a week after Sybil's death than in the months after. The judge found George hadn't independently decided anything. Mary, who was forthright and forceful, had explained why the old will was unfair, and George had simply given in. His agreement was not a decision. It was a passive assent of someone in an extreme state of suggestibility. The solicitor was heavily criticised. When shown GP's concerns, he agreed it would have been improper to proceed. The judge concluded the solicitor's failure to follow the golden rule had greatly increased the difficulties and aggravated the depths of mistrust into which the formerly close family had fallen. If you found this interesting and if you'd like to see more content like this, please do like and subscribe for more content.